Hello and welcome to the Imprint Weekly Podcast. I'm John Kelly, Senior Editor of the Imprint, a daily news site covering child welfare and youth justice around the country. You can read all of our coverage at imprintnews.org or check us out on Facebook or Twitter at the Imprint News. You can also sign up on our homepage for our free weekly and monthly newsletters. And for professionals in child welfare and youth justice, subscribe to our Youth Services Insider section for a closer look at news on business, policy, and practice. The Imprint Weekly Podcast is also a member of the Safe Camp Audio Network. You should check out our show page and all of Safe Camp's other great podcasts at safecampaudio.org on the web and at Safe Camp Audio on all social media. On this week's episode, we talked to Christine Norbut Beyer, Commissioner of the New Jersey Department of Children and Families. She talked to us about New Jersey's exit of court oversight after many, many years under it, how the system has changed since her early career. She started as a social worker at the New Jersey Child Welfare Agency, which is a different name at the time, and now runs it. We also talked a little bit about her thoughts on Miranda-style warnings for parents at the point of investigation. We'll talk about that a little bit more in the news. That has not been an idea bandied about yet in New Jersey, but it certainly has right up the highway in New York. Me and Christine had a fairly long conversation, but let's get in a few headlines before we get to it. And as I mentioned, we're going to start in Arizona, where we appear to have our second family Miranda legislation passed and signed, this time by Arizona Governor Katie Hobbs, who signed SB 1136 this week. It's kind of an all-encompassing Bill of Rights for people involved in child welfare. There's kind of something for everybody. Certainly, youth and foster care makes clear in law that the preferred option for kids in care is with relatives when possible. Mandates a lot of, frankly, mental health and health access services for foster youth that they, by federal law, are already entitled to. For foster parents, it kind of affirms their right to raise concerns about something in a case without fear of retaliation. We're going to actually have a guest from Kansas on soon to discuss that issue within child welfare. When it comes to parents, this Arizona law requires verbal and written notification to parents of their rights at the point that they're being investigated. First, to know that they are being investigated, and then also what the nature of the allegation is. So as a parent, if you're getting that knock on the door, they now have an obligation to verbally and in writing note to you, yes, you are being investigated, and here is what the allegation is that we're investigating. Which takes, I guess, theoretically, some of the vagary out of it. It also, though, spells out very specific things that parents must be made aware of. And I think this list is important enough. I'm just going to read all of it. It's not a huge part of the law, but one, that the worker has no legal authority to compel the family to cooperate with the investigation or to receive child safety services offered as a part of that investigation. That absent a court order, the family may deny a worker entry into the family's home. That the family has the right to seek the advice of an attorney or have an attorney present when questioned by a worker. I would note parenthetically there doesn't guarantee the right to indigent defense or to actually be provided a lawyer. They just have the right to get their own. That anything the person says or writes may be used in a court proceeding. That the family may refuse to do any of the following, and those three things are sign a release of information, consent to take a drug or alcohol test, submit to a mental health evaluation. So to me, that stands out as maybe the most robust in terms of spelling things out as far as the legislation that has been introduced across the country. And this is now several states where something like this family Miranda concept has been introduced. New York's bill's, I think, been around the longest of these more recent movements, although Connecticut actually has had written notification, but not verbal notification required for some years now. But New York's bill, which did not pass, has really almost no detail in the actual fine print of the bill. The Texas legislation around family Miranda, which did pass this term, delegates almost entirely the writing and actual language and what's in the Miranda warning to the state child welfare agency to write. As far as I know, that has not been made public yet. I don't think they've circulated their proposed, rule around what they're going to issue as a warning. I do think, if I recall correctly, it's due pretty soon, like maybe even by the end of this month. I'll follow up, and if there's more information on Texas, we'll update on the podcast next week. This law doesn't exactly write the text of the warning in Arizona, right? But it very much makes clear what has to be emphasized. You have to tell parents, whatever the wordsmithing is that ends up happening, that, they don't have to let you in. You don't have to do anything basically until a court order. And of course, it is worth mentioning, I'm certain in some of these cases, in many of these cases, were a parent to be advised of these rights and shut the door on somebody, they would go get that court order. So anyway, just to recount the score here, we have Arizona and Texas now with laws that require a verbal and written requirement of rights at the point of investigation. Montana has some requirement that also passed this year. It's a little weaker, so to speak, in terms of what they're advising parents. As I mentioned, Connecticut has for a while now had it on the books, in policy that they have to provide written notification. And then states where family Miranda legislation was introduced and nothing happened for last year were New York and Delaware. So my takeaway from this, getting into Arizona as well, is that we now have two very large populous states with a very heavy, conservative legislative presence, where these family Miranda rights bills have become law. And, I feel pretty bullish that we're going to see a lot of states where similar legislation is introduced this year, because it does appear to be something for any legislators that are actually interested in working together, where there's a pretty strong faction in both parties who view this as a civil rights issue for parents. And, a growing recognition of the stakes involved in these cases. They're not criminal cases, but the stakes are as high as criminal cases. And I think that this kind of just, again, reflects a pretty growing recognition on both sides of the aisle ideologically, that it just makes sense for people to be aware of what their rights are in a pretty tense and, impactful scenario for families. In April of 2019, 5-year-old AJ Freund was found beaten to death. It was later determined that his mother was the one who did it, and that his father buried him to conceal the murder. Both have pleaded guilty to charges in AJ's death. They are serving decades in prison. But prosecutors in this case went beyond the direct culpability of AJ's parents, and in 2020, they charged the child welfare investigator assigned to the case. His name is Carlos Acosta, also a member of the McHenry County Board. That's the county that this occurred in Illinois until last year. I think he left. And Andrew Polovin, who was Acosta's supervisor at the Department of Children and Family Services. Why I bring this up, McHenry County State's Attorney Patrick Keneally argued in court during this trial, which started last week, that the two men were, quote, lazy and heartless, and that they are two criminals who didn't give a damn. They are not the first caseworkers to ever be arrested or indicted when a child has died, but it is pretty rare. And if they're convicted, that might be unprecedented. There's two recent and memorable instances of these kinds of proceedings where caseworkers were sort of indicted for involvement, essentially, in the death of a child known to the system. In 2011, New York City caseworkers Sharice Bell and Damon Adams actually faced homicide charges in the death of Marcella Pierce, who had died the year previous in 2010 after being starved and force-fed cold medication, I think by her mom and grandmother. In 2016, Los Angeles prosecutors charged 4 workers, Stephanie Rodriguez, Patricia Clement, Kevin Baum, and Gregory Merritt, each with 1 felony count of child abuse and 1 felony count of falsifying public records in the death of Gabriel Fernandez, who was killed in 2012 by his mother and her boyfriend. His death became the subject of a major documentary series on Netflix called The Trials of Gabriel Fernandez. So what happened in those cases? Bell and Adams both ended up pleading to misdemeanors. They got no jail time and did community service after being charged with a homicide to start. In 2020, 4 years after the arrest of those 4 social workers in Los Angeles, an LA judge just dismissed the case against the 4 LA workers, saying they were factually innocent. That's his comment of the crime. So Polovin and Acosta in this case of AJ Freund in Illinois appear to be the first workers to take such a prosecution all the way to verdict. There's no perfect way to know if this is truly unprecedented or not. I will say I tried to use AI and go hit Google Bard to see if I could find some basic annotation of cases where caseworkers had been tried and convicted, and it was wildly wrong. I mean, it produced a list, and then I went and fact checked it, and not a single one appeared to be correct. That's a scary comment on where those AI machines are at this time. But if you know of instances where caseworkers were actually tried and convicted, hit us up at tips@imprintnews.org. I would love to know. So anyway, like I was saying, Polovin and Acosta kind of appear to be, among the first workers, or maybe the first workers to let a jury actually render a verdict in a case. The defense rested on Friday without having either one of those caseworkers testify. There might even be a verdict by the time that you hear this podcast. We put this out on Monday the 18th. Obviously, if somebody commits a crime, they are fair game to be arrested and tried for it. And in the case of, I think, both New York and Los Angeles, there was evidence here that, caseworkers had falsified records to cover themselves in different ways, which obviously takes it to another level. Doesn't seem to be evidence of that, actually, in this case in Illinois. Now, on the other hand, there is at least the belief that prosecuting caseworkers will bring collateral consequences to the system far beyond their situation, their county situation, or even the state they're in. And that is in two ways. First, making it much harder to recruit and retain workers when that's in the news. And then second, pushing the ones who do work at a child welfare agency to avoid prosecution, which will now hang in the back of their head. This is the kind of belief system here, by just taking more kids into foster care and kind of triggering that sort of foster care panic. Back around the time of the New York indictments, we asked several unconnected officials, so just different people from different walks of life who had not in the same room, about this. And that included Brian Samuels, who was at the time when we asked this, Obama's top child welfare official, or one of them, now runs Chapin Hall. They all use the same phrase to describe the danger, or at least the risk, involved in prosecuting caseworkers in cases, and that was this phrase, chilling effect. Every single one of them in their answers to us said there's the potential for chilling effect. So once we have a verdict or find out what happens in this case of the tragic death of AJ Freund, we will update you on the podcast. You have probably heard of shaken baby syndrome before, as a term that was coined in the 1970s to describe the type of injuries to the brain that occur and connect to an infant being shaken, which of course often occurs out of frustration. Questions have mounted, though, over the past decade, or really more than that, about the validity of this diagnosis, and skeptics of it just got a very significant win in an appeals court in New Jersey. The case at hand sort of rolled two different cases with fathers accused of serious felonies for assaulting their children into one case. And so what happened is, in a January 2022 decision, Judge Pedro Jimenez Jr., presiding over Daniel Nieves' case, declared expert testimony on the syndrome, on shaken baby syndrome, to be not scientifically reliable, and dismissed the indictment against Daniel Nieves. And then in the other case that got rolled in, Michael Cifelli's case, sorry if I'm not saying your name right, maybe Cifelli, Judge Benjamin Buca Jr. barred prosecutors from presenting shaken baby testimony, citing Jimenez's ruling. And so Jimenez, in his ruling, referred to shaken baby syndrome as being, quote, akin to junk science, end quote. And so last week, a New Jersey appeals court agreed with Jimenez, affirming his ruling without really disputing anything about his description of shaken baby syndrome. Judge Greta Gooden Brown, writing for a 3-judge panel that weighed in on this case, said that, and I'm quoting here, biomechanical testing has never proven the premise of shaken baby syndrome, despite the hypothesis being grounded in biomechanical principles. It is just one ruling, but certainly could be a fairly significant precedent, since this is now a state appeals court saying trial judges should not entertain shaken baby syndrome as a way to convict parents accused of child abuse. I'll drop a link to the New Jersey Monitor's story about this case, along with some coverage that the Imprint did in 2017 of a very similar case that called shaken baby syndrome into question. It's also worth noting, and this was a case covered recently by the Marshall Project, a Texas dad who is actually facing the death penalty in a case where shaken baby syndrome was brought in as evidence, is asking the Supreme Court of the United States to review the use of shaken baby syndrome as evidence in this case that condemned him to die. Robert Roberson is seeking the cert from the Supreme Court, and here's the primary question on which he would like the Supreme Court to weigh in. This is the question that they would be considering granting cert for. Does a conviction based on a causation theory presented to a jury as scientific fact and used to establish that a homicide occurred violate due process when later medical and scientific understanding undermines all core premises previously associated with that causation theory. So we'll see what happens in that case and whether the Supreme Court wants to bite. All right, lastly, just a few stories to recommend to you, two from the imprint and then one from our friends at Mindsight, which is a nonprofit news site focused on mental health. We'll start with the recent piece by the imprint's Indigenous Children and Families reporter, Nancy Marie Spears, on some very interesting research on how climate change impacts subsistence life and food sovereignty, and how that connects to family well-being for Native families in some parts of the United States, especially Alaska. It's really interesting story, some really cool research that was done on this. We'll drop a link to that and these other stories I'm going to talk about in the show notes. The other one from the imprint, back in 2014, the imprint published a piece written by Brian Rinker that covered three brothers, Matt, Tarek, and Joseph Bakit, who ran away from an abusive home in 2006. They all ended up in the child welfare system, but while one brother had access to extended foster care once he turned 18, the other two became involved in the juvenile justice system, and that walled them off essentially from eligibility for the extended runway into 21 that is offered in California and now in the majority of states as well. Why I'm telling you about a 7-year-old story is that Rinker, along with our friends at the Marshall Project, followed up to see what became of the three brothers. You can check the link. We co-published this with the Marshall Project, and there's some really truly excellent photography to go along with this story, so I really recommend it. You can check the link in our show notes to read about that and to read up on the original story. And the story of these three brothers, the legislation didn't pass, but this actually prompted some legislative action around trying to ensure that youth who experience either incarceration or just involvement with the juvenile justice system would not have, no chance of getting into extended foster care. Finally, the story from the Mindsight News, the first in what is advertised as a full series coming on something that we've talked about here on the podcast before, and that is the Baker Act in Florida. So in the Sunshine State, this law enables pretty easy access for law enforcement or family or others, school officials, to pursue short-term involuntary commitments of people. And as Josh McGee reports in the first installment here, it's happening a lot to kids, so much that the term has basically become a verb, to be Baker acted. I Baker acted somebody. I'll post a link to the story, and I'll also put a link into our really great interview with Robert Latham, who probably knows more about child welfare in Florida than any single person on this earth, who discussed the Baker Act's kind of intersection with foster care with us back in 2021. All right, when we come back, our interview with Christine Norbut Beyer.
Today's Imprint Weekly podcast is brought to you by Accenture. Change is afoot in child welfare. Change that means agencies focus on results for children and keep far more of them safe at home with their own families. Accenture's child welfare team is leading the way in the effort to ensure technology does its part in that success story. Accenture offers cutting-edge case management tools that ensure agencies can see insights that drive decision-making, and caseworkers have information they need at their fingertips. Together, these tools help agencies stay laser-focused, reinventing child welfare into a source of strength for families when they need it. For more information, visit www.accenture.com/child-welfare.
All right, we are joined today by Christine Beyer, head of the New Jersey Department of Children and Families. In April, the agency she has led since 2018 exited federal oversight related to a class action lawsuit that was filed way back in 1999. We're going to talk about what took so long, right? What worked and what our goals are for New Jersey in the post-lawsuit era. Maybe we'll throw some philosophical stuff as a leader to her too. So, Christine, thanks for joining us on the Imprint Weekly podcast.
Yeah, thank you so much for having me. Excited to be here.
I should have said welcome back because we actually had you during the early stages of COVID to talk a little bit about how you got money out the door to older youth, as many states were struggling to do that. I think some of them still are. So welcome back, and same rules apply. You got to give me one favorite so folks get to know you. The categories are TV and movie, book, musical group, and sports team. I went back and listened. You picked Bruce Springsteen and the Eagles last time, so you got to go in another lane this time.
Another direction. I'll say books. I do a lot of reading. I read like 80 books, like non-work related last year, and I'm probably up to 35 this year already. Yeah, that's how I keep sane, doing this work. But Lessons in Chemistry was one of my favorite books that I've read in the last probably 12 months.
Very cool.
Very female power, energy, historical fiction. Really good.
Love it. So the lawsuit filed against New Jersey's child welfare system was, as I mentioned, first set in 1999. It was over, like many lawsuits are, conditions in foster care, conditions, the length of stay, things like that. It was really in 2003, though, that the state was, fighting it basically until a horrific incident in 2003 when a child named Fahim Williams' mummified corpse was found in a home where his two brothers were also discovered, and they had been seriously abused and alive. There had been, dozens of reports on this family. Yeah. Took them, the caretaker was not their mom. It was somebody that was taking care of them while their mom was incarcerated. And, the caseworker famously had, more than 100 kids on their caseload. So it's not long after that, the governor at the time, Jim McGreevey, settled this. I figure you were, about 30 when this all went down. Were you already involved in the work? Do you remember that day? I mean, do you remember all this?
Yes, I do. I didn't work for the state. I didn't work for public system at the time. I actually had already been working for about 12 years for a private nonprofit, Catholic Charities. Mm-hmm. And the work I was doing then was working with DCPMP, or at the time they were DCFS families. So I knew the work of child welfare, but doing it from, the private sector. And it was at the time that the lawsuit was settled in 2003 that I left Catholic Charities to go work for DCFS. And I will tell you that there were a lot of people, a lot of colleagues at that time were like, are you crazy? Like, you're jumping out of the frying pan into the fire. But honestly, I felt like that was the place to be. It was the place I wanted to be, because that's why I got into this work, to do good work and to be able to impact systems and make change and things that maybe I didn't even really realize at the time. But I felt like, I needed to be right in the middle of it. And so the lawsuit was settled in May. And in September, I started working for DCFS as the regional assistant director in the southern region, which is 7 counties in South Jersey. And so it was right in the middle of, the initial settlement agreement. And there was a lot of work that had happened over the summer, lots of stakeholder groups meeting to try and develop what was then the settlement agreement. And I remember the chaos. I'll say that's really how it felt when I think back on it. It was very chaotic. As you said, people had really high caseloads. Staff were really struggling. Staff didn't want to be known as having working for the agency. It was embarrassing. People were demoralized. And yet staff were coming to work every day, showing up, like still wanting to do a good job. And so the first couple of years of the reform were really rocky. And it's because, we were getting an infusion of resources and cash from the legislature, but there wasn't a really good structure in place to start to make change. We were starting to hire people, but we didn't really have a good onboarding process, or, we had kids sleeping on couches and kids, going from home to home in foster care every night, a different home, because we didn't have enough foster parents, so there was a lot of work that had to be done with recruitment and putting all of those systems in place. And we had like 250 enforceables that had no sequencing, no rhyme or reason. It was everything has to be done now.
I was going to ask you about that. So I know there's always a ton of benchmarks and specific outcomes and stuff involved in a settlement, but, two-parter, because I think people would be interested in this. Like, how does that list get agreed to? Is that like between agency leadership and the litigants and everybody? Like, how does that go? And if you could briefly not go through hundreds of things, but summarize like what you guys signed on to do in excess of just simply being under a federal court oversight, which in and of itself is pretty significant.
Yeah, I mean, I will say that I wasn't in the position at the time where I was negotiating the settlement. And we weren't even a department at that point. It was still, DIFAS was still under the Department of Human Services. But, what happens is you do have a lot of local advocates and stakeholders, the labor unions, like all wanting to weigh in and be a part of what is agreed to. And it is the litigants and the state leadership then who are making determinations about what they'll each, settle for or what they'll agree to. So, as you can imagine, the plaintiff's attorneys, want everything to be reformed. And the state is saying, this is what we were sued for. So this is minimally, what we will do. Not that there weren't a lot of changes that needed to be made. I mean, I don't think anyone at the time was trying to, once we settled, was saying, things are great, but it is about, what you can do. And the more you agree to, I mean, I can look back on this retrospectively because we had so many different elements to attend to. The challenging part of that is the scope starts to just expand. Like we call it scope creep here all the time because, now the monitors at the time that the lawsuit was settled, we had a 5-person panel monitoring us. That also was really difficult because every one of those 5 people had really a different view of what success would look like or what they should be requiring or, how the department or division at the time should be handling some of these different changes. And that I think that added to a little bit of the craziness and the sense of chaos.
So what were, big top line, top 3 things? What did the state need to do to move towards progress in the minds of, everybody involved with the agreement?
Lower caseloads.
Okay.
Workforce needed to be able to pay attention to families. It was really all about safety at that time. Recruitment of foster parents, right? Foster homes, because there were over 13,000 children in foster care in New Jersey when the lawsuit was settled, and there were not enough homes for kids. So kids were in congregate care settings at that time, group home settings for placement, but also going from home to home to home. And as a result, foster homes were overcrowded. We didn't have standards for the number of kids in foster care the way that we do today. Standard, numbers in homes, you can't exceed certain amounts. We didn't have that then. So I would say those 2 things. And then probably also there was a focus on, safety was a big bucket, but it was safety assessments and really needing to ensure the immediate safety of every child in the system, as well as then building out more of a practice model or, how would we ensure consistency across, all services.
I'm going to start with a bit of a philosophical question on how to exit these things, and we can get into your opinion of the nitty gritty of what were the most effective things. But as you mentioned, at the time around the settlement, I looked up 2003 and it looks like the federal data said, 12,800 kids. So it went up a little by the time the T's were crossed. I always screw this up.
Probably,
T's crossed, I's dotted. You take over 2018, it's down already to 6,000 and change.
Yeah.
Last year, because we pester people every year for a live number, so 2022.
Yeah.
We had 3,200 in care. So a bit of
we're down below 3,000 now.
Okay. So kind of a chicken and egg question here. Mm-hmm. Did New Jersey get to where they could exit the lawsuit by reducing its use of foster care, or did the requirements of the lawsuit lead to the reduction of foster care?
I would say the first. I don't think the elements of the lawsuit led to a reduction. I think maybe early on initially, but we were hovering at that 6,000, 7,000 mark of kids in care for a pretty long period of time where, it started slowing down. And I think, some of that was because we were able to do better work, right? You have lower caseloads, you can pay more attention. We did implement a practice model in 2006, 2007. We did reduce and really eliminate the use of congregate care in the mid-2000s for children under the age of 13. And then really did a lot of work on building out the children's system of care. That took a lot of kids also out of foster care because, originally, and I think it happens in many other states still, you have to enter the child welfare system in order to access behavioral health services and congregate services. That changed in New Jersey. So that took a whole portion of kids right off the top from entering care. So
the reason I ask is because, when you look at, it was I think it was probably not recognized enough because we were like in a pandemic and there were other things to worry about. But, there's been a ton of these lawsuits now. And some of the longest running ones were you guys, Connecticut, longer, like another decade longer.
They were like over 30 years. Yeah.
DC, and then Tennessee was another long-standing one, and all of them ended. All of them have ended recently. You guys, Connecticut, DC, and Tennessee. Now, set Tennessee aside for a minute. There's a common thread to you guys, DC, and Connecticut. You have all dramatically decreased just simply the number of kids in foster care, which just kind of got me thinking, like, well, is that really just the answer? Like, it's not like some amazing, reveal that it's easier to manage a system with less people in it. But if I'm hearing you right, it's like, kind of yes, because that really wasn't what the caveat to the lawsuit was about.
That's right.
But it is what made you guys look good enough to get out of it.
Well, yes and no. I might debate that with you because what I would say, I think, is the common thread between Connecticut, New Jersey, and DC is that we all started focusing on prevention in a much more significant way and building out supports and services for families before they enter foster, the child welfare system, really paying attention to the front door, the families who are called in, families that get investigated, what kind of services they get. And I think that is also what makes a difference, that families aren't entering care, or the work you do with your stakeholders, advocates, so that they're not calling kids in, right? There's still too many kids called in, I think, generally across the country. But that's what I think is what's similar about our three systems. And the reduction in foster care is intentional, but you can only do that if you can keep kids safe and families safe outside of the system.
Oh, yeah. And for sure, I didn't mean it to, if it came across as like you guys just both happened to say one day, we'll just take less kids and do nothing else. But I guess my point was like what you just described, which is an investment or realignment around some principles on prevention, not a knock necessarily on the lawsuit, but that just wasn't what the lawsuit was about. The lawsuit wanted caseworkers, a lot of other things. Yeah. And, maybe that's something that we should be talking about as these, because this is not going to end. There will be systems
that's exactly right.
Maybe just, maybe make that the focus of the lawsuits. I don't know. Prevention is a big conceptual thing. Can we drill down a little bit there more and say what has fundamentally been different about, how New Jersey spends its money on child welfare? What are the big things that you're paying for now that you weren't, and that you aren't paying for anymore that you spent a lot of money on?
Well, yes. Okay. So let me think about this, because what I want to say is there was a lot of investment in standing up a child behavioral health system here in New Jersey, right? Separate from Child Protective Services, still within the same department, but separate. And also creating a division of family and community partnerships. And so that was really our division of prevention. And so being very intentional, and also the structure of our department, I think makes a difference, because I know, talking to colleagues across the country, when your children's mental health services are in a different department and you're constantly negotiating and figuring out the money and who's getting the larger share and how is that being spent, that's really challenging. And so I get to, in my department, look at all of those things that impact children and families. And we get to then make the decisions about how dollars get spent generally, and or where we're looking to, expand or request new dollars for new services. So I do think that makes a difference.
So for instance, right, like mental health, a lot of that is tied to Medicaid money. You're saying it's a lot easier for you versus some of your colleagues because that is something within now called DCF there.
The Medicaid office is in New Jersey, actually sits in our sister Department of Human Services. But the creation of the types of services that we offer for children with behavioral health or mental health issues, how we can work when children are in foster care and they need behavioral health or mental health services, like the flow back and forth is much easier. And I do think that makes a difference. And we also get to say, hey, we're looking at, there's children entering foster care, there's a significant need for X. And then we can turn to our children's system of care and say, hey, we need to build out this service, or we need to look to support this issue for these children in this part of the state. And I don't have to go ask another commissioner to support that or get that funded. That may not be their top priority in their department, so it doesn't make it to the top of their budget request every year. So that's what I mean by the structure of how we get to decide and build things for children and families in the state is a little bit different.
How about the role of relatives? Looking back on the days of the settlement, this might surprise you. I don't know. When the federal outcomes report from that year, you guys were one of 4 states that reported not one discharge to guardianship, not one.
That does surprise me. I didn't know that.
Yeah.
Maybe it doesn't surprise me, but I didn't know that statistic.
So how has the role of relatives changed, over these years under your leadership and in general as this lawsuit's progressed?
I would say that under this administration since 2018, it's really significantly changed. I mean, we certainly, children that come into foster care, there's been a push to place them with relatives, in prior administrations and throughout the history of the department. But when it came to permanency outcomes of adoption, kinship legal guardianship, right, or reunification, New Jersey always historically focused on adoption being the gold standard. And so that was really what the system pushed and the state pushed. And so kinship legal guardianship was very rarely used. Even when they were kin, it was adoption, like kin adopted, not necessarily went with KLG. It was seen as secondary. In this administration, we've really started to look at and use KLG because we have a lot of relatives. There's a couple things we know different. One is that some relatives don't want to have the ties severed of their sister or their daughter or their son. And because I think part of it is there's always the hope that they're going to recover, like whether it's a substance use disorder. We know it takes years for people to really recover from substance use disorder. It's like the average of, I think people have an average 7 relapses before they become sober, right? That's the average. So that could take years. And families are saying, well, if parental rights are terminated, what happens in 5 years or 10 years when they are sober and they really can, parent or whatever else happens? So we are using KLG more readily now than we had previously. And I think that also is having relatives say, yes, I'll agree to that, where they wouldn't maybe necessarily agree to adoption. And so we might have looked to then remove them from a child from a relative and place in foster care in order to get them adopted. So there's like some of those shifts I think have happened. And that's kind of anecdotally based on what I know we've been promoting in this administration and having worked for the department previously as the director of DCFS for a period of time, knowing really what we were promoting at the time.
Biden administration has kind of put out some proposed rules around, I think they're aimed at giving states some clarity around their ability to approve kin caregivers on a different track, not adhering strictly to one kind of process for licensing like you would with non-relative foster parents. Yeah. I'm sure you've had a chance to at least kind of look those through. How do you think that would impact New Jersey? Is that something that you are supportive of? You think it would help you guys, or are you already kind of on their wavelength already?
Yeah, I think so. I think we have, again, in this administration, because there's been such a big push to place children that come into foster care with relatives, we have increased the number of kids with relatives. In some cases, we're up over 60%. In some counties, we reached 80% of kids with relatives. And that was a lot of intentional work that it was almost like an all of department approach, like whether you were in IT or human resources or CPMP, your goal was, what do you have to do to help support placement with kin? And so, we saw a significant increase over the last 2 years. Some of that is also looking at what are the requirements, because for, kin to foster, we do license kinship providers the same way we license foster care providers, stranger foster care. And so because of that, we are looking at, do they need now all of the same, coursework or all of the same classes, or are there things that maybe we could pull back on? Always with an eye to safety first, but maybe there are some things that could change there. I think we're also looking at, how do we support kinship parents better and differently than traditional foster parents? Because, when you decide to be a foster parent, a lot of foster parents I talk to say, well, we prayed on this, we thought about this, we talked to all of our family and friends, we talked to our kids. It was 6 months to a year before we finally decided this is what we're going to do. When you're a kinship foster parent, you get a knock on the door or you get a phone call that says, hey, can you take these kids tomorrow? Can you take these kids right now?
Yeah, right.
There's no preparation, right? And a lot of times families, kin also have the added experience of knowing maybe, that there was something not quite right with their relative, or, whether it's a sister or a child or whoever. And particularly in the cases of where parents lose children to foster care as a result of their serious drug use, a lot of times they burn bridges with their relatives. And so there's another layer of kin saying, I'm happy to take the kids, but I don't want to have anything to do with the parent. And that poses a challenge for us also, because, that's what helps reunification. And so those are the kinds of things we're keeping in mind when we're thinking about, how do we build supports for kinship parents? How do we provide them with services and resources to help them say yes, and then continue through, with whatever the children need.
Yeah. You mentioned kin to foster conceptually there. I was curious, the number of licensed foster parents of any kind in New Jersey is way down.
Mm-hmm. Yeah.
I think down like 28% or something like that from whenever we started tracking that, 2018.
Yeah.
So why is that? I'm assuming, from just based on what you just said, that, well, for starters, you just have less kids, so you need less foster parents. But that's one. Yeah, but then do you find that most relatives prefer not to go through that and serve as unlicensed caregivers for you, or
no? So we don't allow that. So if we take a child into foster care and a relative says, I don't want to be a licensed foster parent, I don't want to do that, then we remove the child and put them with someone who is willing to be licensed, or a licensed relative. A licensed, foster parent, traditional parent. People have 6 months, really. We have presumptive eligibility for a period of 6 months where you're paid as a licensed resource parent while you're going through that process. But if someone says, no, but I'll take the child, at that point, we now are involved, and the safety and, all of what we need to be doing to provide services for reunification, that all kicks in. So we don't just traditionally let people say no, thanks, I'll take the kid and we're good to go. It doesn't happen that way.
Are you a professional in the field of child welfare, juvenile justice, or other family and youth services? Subscribe today to Youth Services Insider, the imprint's exclusive section on all the insider news you need to stay in the know. Funding opportunities, major federal and state policy shifts, interviews with key leaders in the field. It's all available only for our Youth Services Insider subscribers. Sign up for a monthly or yearly subscription today by visiting imprintnews.org/subscribe. Our podcast listeners get 10% off their subscription by entering the promo code PODCAST10. That's imprintnews.org/subscribe and get 10% off your subscription by entering the promo code PODCAST10 today.
Jumping around a little bit here, but I want to maximize your knowledge and experience there. So from a leadership standpoint, this is about just the experience of these settlements and being under court oversight. You're the first, well, it hasn't been very long, but you're the first New Jersey director in a long time who has experience being under it and not being under it. Are there any advantages to being under federal oversight? I think I've kind of heard that from some folks in Illinois way back in the day, that it was like low key, we're kind of good in this lawsuit because it kind of forces some structure around how we're funded and things. So I'm definitely going to get you in trouble.
You know what? I was going to say, I think I have said, I think I've said this publicly, that I do think the lawsuit helped New Jersey reform our system and get to where we are today. Do I think it needed to go on for 20 years? No. I mean, I think we could have and should have been out of this sooner. I know the monitor disagrees with me, and the plaintiffs, but I do think we could have been out of it sooner. So I do think that was helpful. I do think having the lawsuit in place, the judge was always very focused on the fact that because of the lawsuit, because of his oversight, the legislature provided the resources necessary, to maintain the progress. And on some level, I think that's right. So I do think that is helpful. But there's also been a lot of progress that has happened, or, we've been able to get new dollars and new growth in areas that were not related to CPMP or related to the lawsuit.
Another leadership one for you. I am blanking on the name of whoever inherited this settlement, but I know that after them came Kevin Ryan, who was there for 4 years, then left to lead Covenant House, and then became a monitor for other ones. And then Allison Blake, 8 years. You've been there 5 years and counting. There's not a lot of great research on this, but generally the kind of rule of thumb estimate is that, the average length of tenure for people in your job is about 2 years, maybe a little less. And that's the average. So a lot of quick outs. Why do you think New Jersey's bucked that trend? And from an insider's view, I know the obvious answer is well, somebody has to learn it all over again. I get that. But just so you have an insider view of this, what is the cost of having high turnover in that job, in your job?
Well, you missed somebody in there, so I'm just going to say. I'm sure I did, When, and Kevin was also he was the commissioner for the Department of Human Services. And then when DCF was created, he became the commissioner here. Okay. And then, and so he really helped structure not just the department, but also that modified settlement agreement, because it was then modified. And I think that's what put us on the path to success, honestly, because we really did flounder for a few years before that. But that put some structure also to the reform effort around looking at quantitative results and then qualitative. We can't get better if we don't put the basic building blocks and structure in place with recruitment of foster parents and opening more offices and training staff and those kinds of things. So I think that was really helpful. And then after he left, Kim Ricketts who's at Casey Family Programs now. Kim was in place for about 18 months. And then when Governor Christie was elected, Kim left and Allison came in. And so I worked for all of those commissioners up until a point that then, I left and went to Casey for a few years and then came back as commissioner. And was in leadership roles really in pretty much all of those administrations. And so I do have a good sense of what was the things that made a difference and what incrementally helped us to get to this place. I do think tenure, the length of tenure really helps. But the other thing is, every commissioner that came in subsequent to Kevin didn't fundamentally change the trajectory of what we were doing. Didn't change now I'm going to do a complete 180 and I'm going to start focusing in this area. The lawsuit and the settlement agreements, I think, gave some structure to, these are the things we're working on. These are the things that we're being held accountable to and we need to report to the court on. And so we're going to keep trying to improve in those areas. So you had that bit of structure. And again, that's not to say there weren't other good things. We didn't have developing prevention strategies was not part of the settlement agreement, but, commissioners were doing those things and being creative in different ways. But I think that helped. Every commissioner who came in kind of had a roadmap and saw what worked and what didn't. And so it was really building on each other's successes and not just, saying, oh, that was their initiative, I'm not doing that, I'm going to focus on this, and constantly being aware of best practices and learning what was successful in other states and other places in the country.
Yeah, which I guess that's still pretty interesting that happened in New Jersey, because it did change parties, Yeah. The leadership changed parties throughout this a couple times.
Well, but the other thing is every commissioner was from New Jersey. I don't know if that makes a difference. I hadn't really thought about that before, but Allison Blake worked in DCFS in the legal department for a period of time. She was a worker, right? So she understood and knew what was, left and worked in other systems, worked at Rutgers. When we built out the whole training partnership at Rutgers, Allison led that for a period of time when I was the director at DCP or DCFS at the time. So we worked together. I think everybody had an investment in the division. Everybody was committed to the division, to the department, to the staff who work here. And I think probably that makes a difference also. It wasn't someone coming in from another state that wasn't really invested in the success of everybody who lives and works here.
Kind of a similar question from the journalist perspective. So it kind of struck me as interesting too that New Jersey has had one reporter, Susan Livio, that has covered this lawsuit and the agency for almost a quarter century.
Yeah.
I should probably get her on the show to talk about that from her perspective.
Yeah.
But from the government leadership perspective, do you see any impact from that? That the main writer on your arc of history here has essentially been the same person all along? Because I'll assure you, the turnover at that position is probably just as bad as child welfare director in a lot of places. But
yeah, I don't know. It's interesting because Sue was with us in the courtroom when our litigation was dismissed in April. And, she and I and Marsha Lowry and Judy Meltzer, our monitor, the four of us had the opportunity at one point to stand together to talk about where we were, what was happening now. And, so it is kind of interesting when I think about that. When I became commissioner, when Governor Murphy was nominating me to the position, and we were talking with some of his press staff saying, these are some things we think you might get asked. And they never said anything about the lawsuit. And I said to them, I can assure you that if Sue Livio is there, she's going to ask me about the lawsuit and what do I plan to do with that. And they were like, yeah, okay. And sure enough, that was the only question that I got, and so we laughed afterward. Dan was like, well, you called it. I'm like, because I have been around it long enough that I knew where the interest was and what people were concerned about or thinking about with regard to now a change in administration and what was that going to mean for the lawsuit? Because, it really has been longstanding and it's what's defined now the Division of Child Protection and Permanency and the department for 20 years. And I think people are nervous now that it's ending. I'll say that. There was some safety in it for the advocates and stakeholders. And so I think there's some concern.
What would that, what is the concern if you had to put it?
That the system that we will fail and go back.
You'll just revert to,
Yeah. To what? I don't know. I keep saying we're so far away from where we were, But that was really one of the reasons also why it was so important from the judge's perspective and from the attorney's perspective to have the legislation. The governor signed legislation in December to create kind of our new oversight, committee as part of, so that there's, continues to be public transparency, continues, that the department will continue to provide information and data. And, we make it publicly available now. There's no intention of it going away. But what I hear is, but what happens when you're not here? It's the unknown of who's the next commissioner, who's the next governor, who's the next, what's the next administration bring? And so really wanting to ensure that these things are enshrined, that We will always have a state central registry. We will have the Rutgers portal available for making, data available in real time. We will have, caseloads now are codified in legislation, that we won't go over, a certain number of cases. So I think that's why the legislation was so important and why we actually detailed more so than I think you typically see in legislation or in statute. But we did put a lot of detail in there. And that was to give advocates and stakeholders, a sense of there's a trigger or something that if we start to revert back, or if there's starts to be problems in the system, or if caseloads start to rise, they can hold that up to the legislature and say, hey, you got to do something.
So let's talk a little bit about present day. New Jersey's one of 10 states that have yet to have a prevention plan approved.
No, we haven't.
You do? You got approved?
No, I was going to say you submitted it.
I know you submitted it. I know. So yours is submitted. There are 2 states that have yet to submit. The rest of you guys are just waiting. Why did you guys wait on submitting, and what are the services that you want to tap into? What's on the list?
Well, primarily the reason we waited was because there wasn't going to be any financial benefit for us in the state to having a prevention plan, at that time, 5 years ago. Mm-hmm. Because we already had begun to develop prevention services. We have 3 evidence-based home visiting programs. The 3 evidence-based programs are home visiting programs that are on the clearinghouse, like we have in all 21 counties in the state, right? But because we had already, started up those services and already invested in that, we could not claim on that money, right? So we would have had to expand and put more state money into those services in order to be able to claim on that.
What were you paying for them with Medicaid?
No, with state dollars. Yeah, okay. With state dollars, but you couldn't use, pre-existing. It had to be new dollars in. And so that really hurt us in a lot of ways because, we have the statewide network of 57 family success centers and, that's state dollars. So there was a lot of state money invested in building up prevention. And we actually, our research staff here did an analysis to figure out that even with our trauma focused CBT, if we would have, said, okay, we're going to expand that, let's see what would be what the revenue would be based on that. And it was a lot of staff time and a lot of staff hours to figure out that we could get $30,000, right? And so we thought, let's wait and see what else comes up on the clearinghouse. Because the other thing is, I didn't want to create a plan that we were going to then have to update as things got added. So that was the other reason we waited. And I feel good. And then COVID happened, right? And so then we kind of got focused on that. And so then that's really what delayed us, from implementing or putting a plan together sooner. But we are looking at, parenting programs now, Triple P. We are looking at motivational interviewing, adding that into our Keeping Families Together program. Keeping Families Together is a supportive housing program. We have over just about 600 families housed and receiving case management services in that program. So by implementing and adding motivational interviewing, we think not only will that improve the service to families, but that'll also be something that we'll be able to claim on. Also, training up our family preservation staff in motivational interviewing. We're looking at the Intercept model. Intercept will be a new kind of program in and of itself, but much of what we're looking at is, how can we add to the services, that we currently have, and if you look at our prevention plan, it's a really detailed prevention plan, and much of it has nothing to do with, being able to claim $40. That's a small piece of our larger prevention plan.
So that aside, what is next for New Jersey? What are your guys' priorities in this administration? What is not a part of the, child welfare family support continuum that you want to see, implemented and kind of firmly imprinted before you leave, whenever that is?
We've been holding pretty close to our strategic plan, that we initially created back in 2019 and have been tweaking it, modifying it. We are looking in a couple different areas. We've been implementing solution-based casework within the Division of Child Protection and Permanency. So really an enhancement to our practice model. We will continue with that rollout. We're spending a lot of time on the development and now the rollout of a new collaborative quality improvement system for, families that are, open with CPMP. It's really about ensuring that families receive excellent service when they are a part of our system. Continuing to look at how do we further reduce the number of kids in foster care. I mean, my goal would be that, how do we create the community conditions necessary that we don't have children in foster care, or, that they can be with relatives. Like when they do have to be in care, they're with relatives. That's like a pretty audacious goal, but something that we're really focused on. And so that brings us really far upstream in terms of looking at what are some of the economic policies that are existing already in the state? And then what are things we can add to that? What we have universal home visiting, we're rolling that out. That's, far upstream from child welfare. That, universal home visiting will be the Family Connects model. And the governor signed back in 2021 that law so that every child born in the state, every child baby entering foster care, adopted, or even stillbirths, the parents will have access to free nurse visits in their home. And those types of programs, we believe will have a significant impact on early identification of, issues or mental health needs of parents, or, early intervention services for children. So a lot of what we've been talking about is how do we further support families and how do we do that differently? We're looking at some cash assistance programs potentially, and how do we pilot that or partner that with home visiting or with these welcome baby kits. We've been trying, honestly, to look at the families that still are entering foster care. And in New Jersey, 50% of children in foster care are under the age of 1, right? They're babies. We know that more children are coming into foster care in South Jersey. So there's less resources there. There's less transportation. There's less access to childcare. So it's those kinds of things that we're working with community, with people who live in the community, to tell us this is what we need. The whole idea of, you hear a lot now about people with lived experience and, how do we integrate them into the work? And we're doing a lot of that, trying to be really mindful and move towards shared leadership approaches. So I think that's that. We're also looking at congregate care. Lots of states are working on reforming congregate care and making changes so that children who go into foster care don't end up in congregate settings. In New Jersey, we really cracked that nut already. I mean, kids are not going into congregate settings for placement. And so they're in congregate settings for behavioral health, mental health needs. And so we're looking now, and with some of our largest congregate providers, with the support of national consultants, to say, how can we create congregate care without walls? How can we keep kids in their home or in their community and get them, high intensity services? Again, it's about not having to remove children from their family and support them in a way and provide the services. But every time I talk to young people, anyone who's ever been in a congregate setting has nothing good to say about it. And so, how do we get them the services, but listening to them and listening to their parents? So that's something that we'll be embarking on. I'm excited about. And I'm going to plug that we have a documentary that is coming out that will be a 40-minute mini doc about powerful families, powerful communities, and the need for transformation in child welfare, the importance of having family voice at the center of that transformation. And I will send it to you if you're interested in viewing it. But
who did that? Who did that doc? Is that internal, or you said something?
Yeah, it's internal. We actually hired a film, a producer director Cheryl Hines is her name. And she worked with us for, just about a year. It's less than a year it's taken from all of the filming to now having it produced. And we now have like the final in our hands. So we're like working with an impact producer now about how to distribute that and get that out. And really, I think it's just an opportunity to raise awareness. It's like another voice in the room of why this is so important, but hearing directly from people who were in foster care as children in New Jersey. So
very cool.
It's pretty good.
I'll get you out of here on this one, but I really am curious for your answer on it. It's I think this is going to be more of a national topic coming soon. So Texas recently passed a law widely believed to be the first in the country to require a, Miranda-style advisory around rights that workers in Texas are going to have to give orally and in writing at the door. And my understanding is that it'll be like their equivalent of your agency that will have the first crack at kind of what that will look like,
Yeah.
Now, your neighboring state, New York, has considered such a bill for a few years. Nothing has passed yet. What do you think of this concept? I mean, would you have concerns about your workforce providing such an advisory?
I think I support parents knowing their rights, right? I do think that that's something that many times families, when they are the subject of an investigation, they're scared, right? They don't know what this means. They only have experienced it if they, heard from a friend or someone else who's gone through it. And I think that giving parents access to their rights and knowing their rights is really important. So I am supportive of that. The challenge, I think, comes in when it's who provides it and at what point. But, I would not be opposed. I mean, I think about it from would there be any impact on safety of the workers? I don't think so. Like right off the top of my head, I can't think about why that would be any different than what they do now, knocking on doors and announcing themselves and kind of why they're there. But, it's something else that we're talking about with regard to what kind of notice do we give parents? And we're not talking about it in terms of like Miranda, but what is the notice we give? And should we be working to assign attorneys sooner, and like at what point in the life of a case, not when a child is ultimately removed, but is there a time sooner that we can give parents representation? And so I think we've started to talk a little bit about that, not necessarily to that, extreme of what's happening in other states, but, it'll be interesting to see how it plays out and what's the impact. I feel like, parents, they need to have due process and they need to understand what their rights are in these cases.
Christine Beyer, head of New Jersey Department of Children and Families. Thanks for joining us on the Imprint Weekly Podcast.
Thanks, John.
Thanks to Christine Norbut Beyer, Commissioner of the New Jersey Department of Children and Families, for joining us today. The Imprint Weekly Podcast is a production of the Safe Camp Audio Network, which is the division of Fostering Media Connections. Please visit safecampaudio.org on the web or at safecampaudio on all major social media. This podcast is produced and mixed by Christine Anjoko with music by Luke Giroux and Cyrus Elia. If you enjoyed this episode, we'd love it if you consider subscribing or giving us a 5-star rating on Apple, Spotify, or wherever you download your podcasts. And we'd really appreciate if you consider supporting our work here on the podcast and in print. Small donations from our listeners and readers go a long way towards helping us grow and cover more great stories in child welfare and youth justice. To support us, super easy. Just visit imprintnews.org/donate. You can follow The Imprint on Twitter and Facebook by searching the handle at The Imprint News, and visit us on the web at imprintnews.org. You can always get us over email at tips@imprintnews.org. I'm John Kelly. We'll see you next week.